check the speed. We are cooking through these. We're good. Let's go.
All right, are these in any particular order, Ms. Clark? Are these in any particular order?
They should be. They're not. They're supposed to, they go.
All right, this first board is entitled Blackhead Hair, 16 Different Individuals.
They are in order of presentation, I am informed.
All right.
And except where there are 3 large teaching boards.
Yeah, the large white pieces.
Which are, which are how the analysis done.
Your Honor, just one question. I don't know if the people are representing that we also receive these pictures in advance, or copies of these pictures?
These are, no, I'm not representing that. These are taken from the FBI atlas. They are not evidence in this case. Well, it should be.
They're a demonstration of 16 different types of blackhead hair. Is that what this is?
Exactly.
All right.
We object to this kind of a demonstration without some showing that these 16 people are somehow representative of the black population as a whole, or some data can be given as to what distribution these people are, or where they came from. I mean,
What is this, Ms. Clark?
This is just to demonstrate ranges of characteristics. It's not meant to be dispositive or it's not meant to represent all possible hairs that might exist or what they all might look like in the entire world.
All right, when we say black hair, are we referring to persons with black hair or African-American hair or what?
African-American hair.
Okay.
And it's just demonstrative for Mr. Deidre to be able to explain to the jury the range of the different kinds and appearances of hair that he sees under the microscope. We have one for Caucasian hairs as well.
All right, let's see that.
That's, I'm going to show counsel the photographs because they need to be mounted.
And these are also from the FBI Atlas?
Yes, Your Honor.
All right, next item.
For the record, I object to these on the same
I
grounds.
object.
The implication here from both the exhibits is that there's some well-defined
Sanctions.
way to break hair down into categories, as referenced by this board, when in reality, there may be many kinds of hair similar to the one on the top left, but slightly different, that different examiners will see differently. I would object on that basis.
Well, that's what cross-examination is for. The witness is not going to represent that there's no other kinds of hairs in the world but these. He's going to say this is a sampling. I'm showing you how they look different under the microscope. That's all it is.
All right, let me see the third one.
Did change my resolution more. So, is this still blurry like the last video?
Yes.
Who's doing, I'm getting objections from Whitfeld and from...
No, you're going to get, no, Mr. Blazer's handling this, so I assume he's handling the witness.
No, actually, it's Bailey.
All right, one person on the boards. All right, known head hairs from Nicole Brown Simpson.
This is, this shows the photographs of Nicole's exemplars as seen under a microscope and where he found matches in the questioned evidence, not all of them, just some as a representative sample.
Are we confident in our terminology match? Is that something that's in the nomenclature for hair comparison?
It is not.
Wait.
I would ask that the word not be used because after all DNA evidence.
Oh, excuse me, counsel. We're going to get one counsel on this. Mr. Bailey, do you want to handle this, or
Yes,
Mr. Blazer?
I'm asking the word match not be used. Most of the hair technicians.
No. Here's the issue. Who's handling this witness?
I am.
All right.
Why don't we inquire of the witness whether the term match is appropriate or not? He's the expert.
Well, we'll get to that. We're looking at the boards first. This is a comparison of hairs. I take it the top row is Nicole Brown Simpson exemplar hairs, and the bottom row are hairs from various places associated with the crime scene, correct?
That's correct.
All right, what's the objection to this?
Okay.
All right, next board. All right, this board is entitled Known Head Hairs from Ronald Goldman. 4 photographs, 2 photographs to the right, head hair from Goldman's shirt. Any objection to this?
Okay.
All right. Nice boards. Yeah. All right, this is entitled Elimination Head Hair Samples and appears to have 16 photographs of hair, which is, each one of which has a name which appears to represent one of the many witnesses who have testified with regard to this case.
Yes, Your Honor. As the court will recall, Ms. Brockbank testified to the collection of exemplars of various police and lab personnel who were then, whose hair was then microscopically compared by Mr. Diedrich against certain question hairs in the evidence. And this board was prepared to demonstrate the differences in their hair and why they did or did not match.
Any objection?
Yes, Your Honor.
All right.
Following objection, like who was not shown the night before, the witness was called. The prior witness has testified that in order to fairly compare head samples that he taken from different parts of the head, he did not believe there was sufficient samples taken here until the evidence shows that the majority of the head.
Except that we have a stipulation to that effect. We have a stipulation to the effect that the exemplars were taken from the police and lab personnel in a forensically appropriate manner.
All right, let's see the next one.
But also, Your Honor, for the record,
Yes.
we cannot get these photographs.
Ms. Clark?
I don't know.
All right, check on that.
I know that the hair samples were of course furnished to the defense, the samples themselves.
I don't believe, Your Honor, these have been collected by the time of the burning photograph.
No. The hair samples themselves were sent to the defense. A number of times.
All right, next board.
These are the known head hairs taken from the exemplar for the defendant, and the photographs that depict the question hairs recovered from the evidence at the crime scene, which match those hairs, in the opinion of our expert, Mr. David.
Okay.
All right.
Except, no, Your Honor.
I don't think that we're going to get to the testimony concerning those last couple of boards until tomorrow.
Well, let's see where we are. Let's see the next one. How many of these do you have, Ms. Clark?
500.
All right,
And then teaching points.
let's go.
This is another board, same thing. Defendant's head hairs from the known sample, and then photographs from the crime scene evidence. Photographs of hairs recovered from the crime scene evidence, which I believe Mr. Deacon will testify are matched.
All right, the interesting one being also Q23, the hair from Goldman's shirt. And I can't see
I'm sorry, Your Honor.
Q47.
Q47 hair from the knit cap.
Okay. All right, Mr. Bailey?
No objection, except the same objection.
All right.
This board compares the known cotton fibers from Ron Goldman's shirt to question cotton fibers recovered from items of evidence at the crime scene. One from the Rockingham glove, two from the Rockingham glove, and then one of the photographs depicted from the Bundy glove, and two photographs from the knit hat. Okay, this is fibers that are from the knit hat found at the crime scene, Your Honor, the blue knit cap, and the known as K47. These were exemplars, I think, removed by Mr. Diedrich himself from the cap, and those are compared to question fibers from Mr. Goldman's shirt in the lower two. On this other side, K17 is a known fiber from Nicole Brown's dress, and that's compared to fiber found on Mr. Goldman's shirt in Q23.
No objection.
All right.
This is the board concerning the match of Bronco carpet fibers. On the upper row, we have known samples K14-9. We have two for K14 and one for K9. K9 shows the scanning electron microscope photograph of the fiber. The other two, I believe, are microscopic photographs. They're compared to fibers found on the Rockingham glove and on the knit cap.
Mr. Bailey, which photographs have you not seen?
Any of those.
Ms. Clark?
If I'd be given a moment to find out.
All right, let's see the next one. Let's hold that one
This
aside.
was the last board made, so it may be that we just got these photographs.
All right, this is Bluish Black Cotton Fiber Associations.
That's correct. The bluish black cotton fiber, Your Honor, there is no known exemplar for. However, Mr. Diedrich found bluish black cotton fibers on the Rockingham glove, on Mr. Golden's shirt, and on the defendant's socks, which all matched each other, which is indicative of what was worn on the night of the murder.
Without much further foundation, we object to that.
Well, the foundation's all going to be laid by the expert.
At the moment, we haven't heard of it. Okay. Right.
This is a comparison. This is one of the blue black cotton fibers that we indicated were found on Von Golden's shirt. The upper one was found to be wrapped around a bloody hair that matched those of Nicole Brown. The lower one is another fiber found on Von Golden's shirt, again, the blue black cotton fiber. To the left of that, those two photographs, as you face the board, is a fiber, a blue cotton fiber from Von Golden's jeans, for the purpose of demonstrating some of the differences that can be seen in fibers and in their color. So the two on the right-hand side are a match to each other, and the single photograph to the left of that is there for comparison purposes.
So how do you explain the wrapping around effect?
The wrapping around of the fiber around her hair, during the murder, the defendant was wearing fabric of this kind of fiber, the blue black cotton fiber, and that in the course of stabbing, got some of her hair, or in the course of grabbing her hair back, in the course of the stabbing, got one of her hairs on his clothing, which, when he went back to Ron Goldman, transferred to Ron Golden's shirt.
That's an awfully tight wrap around of a small fiber around a hair, is just the point I'm making.
Mr. Diedrich will be able to explain that.
Just curious. All right. All right, Mr. Bailey, your objection is what?
Same as before, Your Honor, I don't think it's adequate foundation. As Mr. Diedrich testified, perhaps they can lay a foundation, but I don't see one yet.
Josh is the only cat that climbs up the curtains constantly.
The foundational
I don't know
deficiency
why.
that counsel's referring to
Just
is a lack
climbing
of
up the curtains. Hey, Josh, how are you up
Okay, here's
there?
from Ronald Goldman. All right, Mr. Bailey, any objection to this?
No.
All right. Dog hair comparisons.
On this board, we have the known samples in the upper row again. The first three, as you face it from the left to the right, being from Cato, and the last one from Chachi on the upper row. And on the bottom row, we have question samples taken off the glove found at Bundy, one of which, Q7A, appears to match Chachi's hair. And then the other question samples that match Cato are from the glove at Rockingham and the glove at Bundy. Now we have teaching boards. Carpet fiber variations.
Objection.
And again, this is another instruction board concerning fibers. John.
This is not my day.
Rotate.
There you go. I've seen it, thank you. Last one.
Check the way it's going up this time.
Cotton fibers. Teaching board instruction.
Any objection? All right. All right, I have,
We have summary boards, which you've already seen.
yes. All right, I have 5 object.
So just one more thing. With respect to educational, we have a series of photographs on laser showing the microscopic comparisons, how they're conducted, and the different...
Don't you think we should see those?
Sure, that's what I write. Mr. Berringer will show it to us now later.
Shouldn't we have seen these a while back?
We haven't seen it corrected.
We just,
All right, let's see. How many of these photos do we have on the laser disc?
of these teaching photos, Ron?
Yes.
John? Five, is it? We had,
All right. First one is transmittance. Appears to have something to do. What is this? Color wavelength?
yes,
Blue fiber. Blue fiber. All right, Mr. Bailey, any objection to this?
color comparison chart.
All right, let's see the next one. Absorbance. Any objection to this?
That shows measurement by light absorbance, comparison of fat fibers. I'm sorry? It's an example, right. Right, it's not our evidence, correct?
No, it's just an example.
All right, okay. Absorbance, brown carbon fiber, brown carbon fiber.
Again, an example, not our evidence.
Next one.
This is for the purpose of teaching the components of hair.
Any objection? All right.
Again, same thing. Purpose of teaching components of hair.
Title hair shafts. All right.
Same thing for teaching
Fibers.
fibers.
All right.
This shows the process of examination using the stereo.
Indicating the use of a microscope.
This shows the process of mounting
A hair.
a hair.
All right, this is hair analysis pulling evidence from a pillbox.
And place on glass slide, cover slip.
Any objection? Next.
Her mount,
Next.
blotting off the excess solvent. Looking at the slide under the stereo microscope. And a close-up view of the slide under a stereo microscope. We already did this. Fiber analysis. This shows the FTIR with microscope attachment. This shows another form of fiber analysis, the microspectrophotometer. Another aspect of fiber analysis is the fluorescent microscope.
Got it.
Sorry?
Fluorescent microscope.
Next.
Okay, this is just demonstrates the photograph that is taken as a result of the magnification done by a scanning electron microscope.
Can't read the legend of the right one.
1991 Bronco dash 1850 nylon.
Pardon me?
1991 Bronco dash 1850 nylon.
Next.
Same thing. This is-
92 dash 94 Bronco dash 1405 nylon.
We haven't seen these before. Do I understand these from other Broncos?
Yes, right? What is that? From other Broncos?
From a representation from a Bronco, yes, from that year.
From 92? Or 92 to 94?
Probably, it doesn't matter. I mean, I think it was a 94 model that I got a sample from.
It was a 98, not this Bronco.
Or for comparison purposes?
Just an illustration, just show how they changed.
Next.
1995 Bronco 1405 nylon.
Well, it's kind of like the end to be showing us all this now, see what 95 Broncos do with 94 Broncos.
Just shows the changes. The manufacturer changes.
95 is on short, and it's 93.
It's illustrative of the differences that you can find in fiber shapes and cross sections.
All right, next.
Okay, these are the last two. This is a Elmo version.
Court's had the opportunity to look at these exhibits. You can take your places again, Counsel. All right, either side have any other comment they want to make as to these items?
It's them that are muted, not me. The judge has it muted right now for some reason.
Totally disabled to examine any of these materials, have the ability to challenge them, and this was deliberate surprise to cause that result.
Sanctions!
At a stage in the
Sanctions!
trial where continuance
Taser.
is no remedy, because that's punishing this jury, which has been punished enough. There is only one remedy for these violations, Your Honor, and that is preclusion. It would be totally unfair to stop this trial long enough to permit us to go through each one of these photos. Dr. Morton has seen the original, but he's had no basis to compare and see whether they're taken out of context, whether this is a piece of advocacy or a fair presentation. As to that photo in particular, it can never be anything else. The sources of blue fiber in California or the United States are infinite, and we will need to prove up and be able to cross-examine all the possible sources, particularly from the environment where these were taken. And that's going to take some time, and we could have done it had we been given any kind of decent notice. As far as the photos of the Bronco from various years, that was sprung on us today. Now, we've been checking carpet all over the United States very dutifully in an effort to represent this defendant in a responsible way. And at no time have we ever run across a notion that there is a periodic change. Had we been warned of that, we could have checked it out and either said, yes, that's correct, we won't take the court's time up with a meaningless challenge, or been able to cross-examine on the point as to when the changes were made, how many million yards of each fabric were created, what cars they were installed in, what houses, et cetera, et cetera. The last matter that I would like to take up, and it's one that is very disturbing, and we've been waiting for it to erupt. The FBI book on hairs and fibers says very clearly that the most that can ever be said is that a hair or a fiber is similar to or cannot be eliminated from a same source. That can never be identified.
Consistent with. Yes.
Consistent with is permissible. Match is never permissible and is a highly dangerous word because a lay jury looking at photos of hairs of ostensibly the same color with some similar characteristics may get the impression, if the wrong language is used, that this is an identification of the defendant when it's a far cry. There is not, Your Honor, even a database from which one could come up
All
with
right, guys.
as is attempted to be
Enjoy.
done.
I'll be right back,
No
okay?
one knows how many people have hair that is indistinguishable from that on the hat or from that of the defendant. And for any hint to be given that this even comes close to an identification of the defendant's hair would be ground for a mistrial. And I would ask, Your Honor, if that happens, you strike all the testimony on hairs, because the parties are forewarned. I do not expect there's been any change in FBI policy about the value of this evidence since this was published in 1977. If there is, none of us has heard about it, nor did any of the literature ever go any further than this. And the use of the word match or the same as or any similar articulation is simply deadly.
If you recollect, I think I was the one who noted that initially.
Yes, I know, Your Honor, but I heard the word in court today, and that's why I'm hoping that you enforce the rule very stridently. What we don't need at this point is a mistrial. Even if the defendant could not be tried again, to prevent him from putting on his very strong case before this jury, this court, and this country, after suffering all these months, would be a greater injustice than if he was struck dead right this moment.
All right, Mr. Bates, so I understand the nature of your objection, since obviously I'm not privy to this information either. You're objecting to the bluish-black cotton photographs? You're objecting to the photographs regarding the periodic change in Bronco carpet?
Yes, Your Honor.
And you're objecting to what else?
The hair elimination photos
Hair
of the
elimination.
police officers and others who were on the scene. Those could have been given to us last December, or no later than January. There's one final objection, Your Honor, which I noted during the recess. You note that the chart on the dog hair comparisons compares 3 of Cato's hairs to the 2 gloves, and suggests that Cato's hairs, or hairs similar to Cato's, consistent with, were found on both gloves. The last column suggests that a hair similar to Chachi was found on the Bundy glove. Now, that could be taken as having some significance if certain inferences were drawn. However, after that comparison was made and after the witness came to his conclusion that they were similar, he discovered by accident that there were many, many dog hairs in Ron Goldman's home, that they were similar to Chachi's, and those have not been mounted to give the jury an opportunity to look at that comparison. Because if Ron Goldman had dog hairs on his clothing, and they dragged Ron Goldman's body out and it touched the glove, that would certainly explain the presence of a dark hair, not Cato's. Obviously, Cato's hairs being on both gloves is not of great significance, but the Chachi one is. We're reading from Mr. Diedrich's notes about his after discovery and about his comparison and about his statement that they're similar, and the failure to mount those should preclude that last column from coming before the jury.
All right, thank you, counsel. Ms. Clark?
Counsel's hyperbole notwithstanding, the photographs of which he complains concerning discovery were photographs taken for the sole purpose of creating an exhibit in court. The evidence itself was turned over to counsel long ago and on many occasions.
All right, we're talking about the hair elimination photos, correct?
Correct, as well as the photographs, as well as the blue black cotton fiber photographs. All of the evidence has been been given access to the defense on multiple occasions. With respect to the photographs of everything with the exception of the Elimination Standards Board and the blue black cotton fibers, those photographs were given over to Mr. Schulberg on September 27th. We received a phone call from Mr. Schulberg some minutes ago in which he informed us that no one from the defense team has called him today, contrary to their representation to this court just a half an hour ago or so. He was sitting at home and his phone has not rung. He is still at home and available for conversation. He is in possession of the photographs, all of the exception of which I've already noted to the court. Nevertheless, the photographs are not the evidence. The photographs are simply taken for the purpose of preparing exhibits in court. It is the court's order, in my understanding, that exhibits are to be shown to the defense the day before. We anticipated the cross of Susan Brockbank would take longer than it did, and we anticipated showing the defense all of the boards in their completed form at the close of business today, with the idea that none of them would even begin to be used until tomorrow. The reason for that is that the boards had to be modified and changes needed to be made in labeling before they were complete. I wanted to be able to show the boards to defense in the manner in which we intended to present them in court so that any objections that we drew would be based on what we're actually intending to use as opposed to anything that needed to still be modified. So the boards were not even completed until this afternoon. So with respect to these exhibits, and it is a complaint I understand from the defense about the exhibits, we will agree not to use the blue black cotton fiber board until tomorrow, and we will agree not to use the Elimination Standards Board until tomorrow. And I think that that would bring us into compliance with the court's order. There was no willful desire to withhold this from defense. We didn't have it to present to them. It was only an exhibit. It's not evidence in and of itself. And so until the exhibit is prepared, we have nothing to show. With respect to the complaint counsel raises concerning the significance of the match between the blue-black cotton fibers found on various items of evidence, that sounds like fertile ground for cross-examination, but it does not sound like an objection that is legally sustainable in terms of preclusion of any of the evidence. And with respect, and I believe we will lay the foundation for that with Mr. Diedrich. He will indicate to the court why it is appropriate to declare a match between those questioned fibers in his experience and judgment.
Is he going to say it's a match?
Shall I ask him?
Well, no, I assume you've interviewed him.
I have, and we have used the term match. I have not specifically asked about that term because I did not think it would be objectionable, because it's never going to be indicated to the jury that there's a match without also saying that he cannot rule out other hair type, other possible sources that have the same characteristics as the questioned hair or the exemplar hair, as the case may be. There will be no time in which Mr. Diedrich will state a conclusion without that qualification. So there's not going to be any misleading to the jury. And the court is well aware that it is not my practice to put an expert on the witness stand or any witness on the witness stand to say something that is not forensically or legally defensible or appropriate. And I've never given counsel any reason to believe that I'm going to ask Mr. Diedrich to make a conclusion concerning identity on the hairs or the fibers.
All right, well, let's start from the top then.
Okay.
With regards to these photographs that I have here to my left, the bluish black cotton fiber associations, with regards to these 8 photographs, when did they come to the possession of the prosecution?
We never got the photographs, Your Honor. Mr. Diedrich prepared the board for us. You know what I mean? We weren't furnished with a stack of photographs. He brought a board in with him that we just completed the labeling on this afternoon.
When did Mr. Diedrich conduct this analysis with regards to the blue-black cotton fiber? Ballpark.
End of 94, perhaps.
All right, and is this information in his report that was given to the defense?
Oh, yes. As was the evidence itself given to the defense. I mean, the defense has had the fibers as well as his reports and notes concerning all of the items that we're going to
And
present.
do the notes indicate taking of photographs?
No. Again, the photographs, however, Your Honor, are not taken for any purpose, analytically speaking. They're not taken for the purpose of assisting Mr. Diedrich in his examinations or informing any conclusions. The photographs are taken solely to illustrate to the jury what it was he saw. It's solely a demonstrative exhibit. That's its only purpose.
When did the prosecution become aware of the existence of these photographs?
I mean, the boards that I was aware of were the boards containing the defendant's known hair samples compared to the question hair
No,
samples.
my
But
question
the
is...
blue-black?
The blue-black, when were these photographs given to the prosecution?
Well, the board was brought into us, the first time I saw it was last week, and it was not labeled appropriately. I asked that it be relabeled so that it would be more precise as to the source of everything, and that was completed today. I thought I understood the court's order concerning exhibits to be that it was to be presented to the defense the day before presentation in court. Concerning exhibits?
Not regarding exhibits, but this is evidence, it's not just exhibits.
Well, it's photographs of the evidence, but it's the photo. You know, the point here is, Your Honor, the photographs. The witness does not compare photographs. The witness compares the fibers themselves.
Mm-hmm.
The photographs are only taken for the purpose of showing something to the jury, for explanation and demonstrative purposes, for teaching. I really don't understand the problem here. You know, the defense has had the.
No, counsel, the problem is this. You have a picture of a fiber from the Rockingham glove. You have a picture of a fiber from Mr. Goldman's shirt. You have two fibers that are similar that are found on Mr. Simpson's socks. I mean, obviously, and you've got a picture of Mr. Simpson on the evening in question wearing what appears to be dark blue or black clothing. And I suspect that you're going to argue from that given the nature of the struggle between Mr. Goldman and the alleged assailant, and given the type of clothing that Mr. Simpson was wearing, you're going to argue, and given the fact that it's on the socks and it's on Mr. Goldman's shirt and it's on the right-hand glove, you're going to argue that this is fiber from the clothing of the assailant.
Yes, Your Honor, I
Right.
am.
And
But
don't these photographs demonstrate the similarity of the blue-black fiber?
well, yes, and the court has used the operative word demonstrate, because I could make that argument to the jury with the witness's testimony, which the court would not preclude, because discovery of the conclusion reached by the witness concerning his examination of the evidence was timely furnished to the defense, as were the fibers themselves timely furnished to the defense, not once but 4 or 5 times. And so now the only thing we're talking about is the fact that the witness has prepared an exhibit for the jury to graphically demonstrate what his testimony is going to give, and which the defense has known about for months.
All right, my question is, when were these photographs provided by the FBI to the prosecution?
The photographs were mounted on a board by the FBI, and the board was brought in. I last saw it last week, Your Honor, in an incomplete form. And
Mr. Diedrich, when were these photographs taken?
In late '94. Can't say specifically what day.
And when were they provided to the prosecution?
The charts weren't sent until probably April, maybe, April or May. I believe all the charts that were prepared from the photographs. The last charts came in probably right around the 1st of June, I believe.
All right, how about the Bronco changes? Can I see that again, please? Mr. Fairtlow?
These are not the photographs of the defendant's Bronco carpet. These are simply illustrative photographs of carpet fibers from the years 92 to 94,
Well, 91 through 95.
taken for illustrative purposes in demonstrating differences between carpet fibers.
Is mention of this made in any of the reports prepared by Mr. Dietrich?
Mention of the taking of photographs?
Yes.
I don't believe so.
And when did these photographs come into the possession of the prosecution?
Last week,
And Mr. Dietrich, where did you get these photographs?
They were taken in the laboratory.
And these are samples provided by Ford Motor Company?
Yes, they were.
Did you write a report with regard to this?
No.
All right, how about the hair elimination photos? When were those taken? Yes.
It would have been in December of 94.
And when were they transmitted to the prosecution?
Again, all of the charts came about the same time.
So that would be April or May?
That's correct.
All right, and the last thing is the objection regarding the fact that the non-inclusion of another Chachi hair, is that what the problem is?
No, Your Honor, hairs from Goldman's home that look similar to Chachi's, to Mr. Dietrich, according to his
Got it.
notes.
All right, Ms. Clark, any comment on that?
be the subject of expert testimony, Your Honor, and certainly since counsel is well aware of the facts of the examinations conducted by Mr. Dietrich, it's subject to cross-examination. Mr. Dietrich has certain conclusions that he's drawn from what he has seen. The existence of other similar dog hairs that I believe, I don't know what Mr. Dietrich would say concerning that. I had not determined whether I would even ask Mr. Dietrich about the comparison of the Chachi hairs. I have shown all of the boards that we have without the intention necessarily of introducing all of them before the jury. The reason that
All right, let me ask you just a factual question. The representations from Goldman, was this from Mr. Goldman's apartment or from the Goldman residence in
Department.
the apartment?
his apartment, yes.
All right, okay.
Let me also indicate this to the court. I did not know what boards had been sent in because I'm in one place and they came into another. But it wouldn't have mattered had I known, because I needed to interview Mr. Dietrich and see what, if any, boards I wanted to use. And those interviews did not begin until, I spoke to him a long time ago in general about all of our evidence in this case. But that was before he'd even taken a lot of these photographs. When we really sat down to prepare for his testimony, it was last week and a little bit the week before. And it was only last week, after having gone through what he would testify to, that I began to look at the boards to see what, if any of them, that he prepared that we wanted to use. At this point, I've been over-inclusive and shown everything with the idea in mind that not necessarily all of it would be used. But I didn't want to take any chances, knowing that, we have to produce these boards a day in advance. And in case we...
What aren't you going to use at this time?
Well, what I had seriously considered not using the dog hair comparisons board. I hadn't even made a final determination as to whether or not I would ask Mr. Dietrich about the Chachi hairs.
All right, in the scheme of things, that's probably the least of my concerns here.
With respect to the...
But I'm more concerned about the fact that this blue-black cotton fiber, I can see the demonstrative purpose for this. It's pretty clear. To say that the photograph is not evidence is not a credible argument. The fact that these photographs were taken in the end of '94, and that they were delivered to the prosecution sometime in April or May, that would trigger the obligation to turn copies of those photographs over if the people intend on using evidence of blue-black cotton fibers.
Well, Your Honor, but the...
As to the hair elimination, the fact that these photographs were taken in December of '94 and transmitted to the prosecution in April or May, and if there's a reason, if they're evidence in this case, they should have been turned over to the defense.
But, Your Honor, there's a real distinction to be made here. The witness made an examination and a comparison, and his conclusions and all of his examinations and notes were turned over to the defense in a timely fashion. That's the evidence. The fact that he
All
took
right, if that's
photographs.
the evidence, then you don't need the photographs.
The photographs are an assistance. They're a demonstrative tool, as the defense has been using them and springing them on us at the last minute as well. And we've had numerous occasions to object to the defense withholding their demonstrative exhibits till the very last minute. But we were not attempting to do that in this case. I didn't even know what I was going to use until a few days ago, and I didn't know what final form it would take until all of the corrections were made. And I did not intend to have to use them, even think about using them until tomorrow, because the cross-examination did not take as long as I thought it would.
All right, I'm not as concerned about the one-day rule as far as turning over exhibits, but I am concerned about the failure to turn over photographs. They're clearly evidence. I don't care what you call them. All right, any other comment? Mr. Bailey.
3 points, Your Honor. First, Mr. Neufeld did place a call to Mr. Schulberg. Dialed his number, got no answer. I'm sure
I'm
you're
not
not terribly concerned about that,
I'm
but
not
I want the
concerned.
record to be straight. Number two, to exacerbate this situation, more than a month ago, I went to Ms. Clark and said, for my purpose, I would like to shorten down, wherever possible, the presentation of expert evidence, and I know there's a lot of it. Could we get together and go over what it is you want to present? She put that on the record. I was watching her on television when she told you, said we were going to do that. So this all could have been avoided. Furthermore, these pictures that were handed to us at 2:45 aren't worth much without the labels. If we can't see the board speaking to the jury, we don't know what the board's going to say. And they certainly could have given us fair warning about this and give us an opportunity to answer it on Mr. Diedrich's cross. And we don't have that opportunity now, and preclusion is the only fair remedy. The suggestion that these are not evidence flies in the face of the evidence code. They are evidence because if you're not going to admit them as evidence, the jury should never see them. And the suggestion that because we saw the fibers through a microscope, we're not harmed by these photos popping up is specious. That's like saying because you visited the crime scene, you're not entitled to see the photos of the crime scene we intend to put in evidence. Your Honor would never buy that, and yet it's the same story. Thank you.
Mr. Bailey raises the very point I'm trying to make. They have seen the fibers themselves. They have seen the notes and the conclusions of the witness. They could take their own photographs as well. Nothing has been precluded them at all. The only thing that we have done is to graphically depict what they already know to be the case in terms of the witness's testimony and his conclusions. They're not taken by surprise. But in no way are they surprised by the fact that Mr. Diedrich has made the conclusions that are depicted on this board. And that's really the bottom line. There is not surprise. Now they can see the photographs. All right, they can see the photographs, but they know what the conclusions are. And Mr. Bailey and I spoke about shortening down the testimony, and that concerned Denise Lewis and Susan Brockbank. I told him what I was going to elicit from Mr. Diedrich, and that has not changed. I have not misrepresented to him what he would be testifying to. I was not aware of all the boards that were possible to be used at the time we spoke. As soon as they were corrected and ready to be shown to the defense, they are shown. The defense has ample time now and to the conclusion of business today and even into tomorrow to examine the photographs and get advice from their experts as to how to handle them on cross-examination, because the bottom line for cross-examination is not the photographs, Your Honor. The cross-examination will go to the substance of the testimony and the weight and power and force to be given those conclusions concerning question fibers that have no known standard to be compared to. And the photographs aren't going to change that cross-examination any at all. And that's the bottom line. That's why what you're doing is simply preventing the jury from understanding better what the witness is talking about. That's what the court is basically going to do if it precludes the use of the photographs. But it will not. But in allowing the use of the photographs, it won't change counsel's cross-examination. His cross-examination has to remain the same because the conclusions were known to him. The groundwork is laid for what the cross has to be. The existence or non-existence of photographs does not change that cross-examination in any way, shape, or form. And that's what matters in terms of the right to be prepared.
All right, thank you. Well, there's an old Chinese saying that a picture is worth 1,000 words. There's no other reason to present these photographs other than to use it as clearly evidence of the fiber evidence that we have here in the other comparisons, and to argue that it's not evidence is a specious argument. All right, the objection to the first objection was to the atlas. First two objections were to the atlas photos regarding various types of fibers. Those objections will be overruled. Those are general demonstrative exhibits, and I think counsel is well prepared to deal with those. As to the dog hair comparison board, I think the fact that the chart does not include dog hairs that were later found at Mr. Goldman's apartment, and that those dog hairs at Mr. Goldman's apartment are comparable to those from the dog Chachi, I don't think that's an objection to preclude the use, since the prosecution uses it without that information at their peril, since the obvious argument will be that by not including it, they're attempting to hide something or not providing a complete picture. As to the Bronco comparison, they appear to be electron microscope pictures of those fibers. I will overrule the objection to their use. However, the prosecution may not use those until the defense has had time to conduct any additional investigation that they need to conduct. It appears to the court that an obvious area of inquiry would be to the Ford Motor Company to ask them about the types of fibers that are installed in the Broncos, and whether or not that changes over time, whether or not there's any uniqueness to the source, since these photographs were made available to the prosecution only last week, and because this information was available to either side, anybody could have picked up the phone and called Dearborn and gotten this information. I don't find a violation there. I am much more troubled, however, by the hair elimination photos and the blue-black cotton fiber photos. I have to take into consideration the fact that the defense did have in its possession Mr. Diedrich's reports regarding the comparisons, and in fact had access to the samples themselves. However, the photographs are an important part of that analysis. And what I will do is, since the defense has their counsel here, has their expert here, has the photographs with their markings here, I'm going to recess this matter until tomorrow morning at 9 o'clock. I'm going to direct the prosecution to make all of these exhibits available to the defense overnight. They can examine those. If that is still not adequate time to prepare and to compare the reports with those fibers, then I'll consider other sanctions, as I would like to finish this case sometime this lifetime.
Your Honor, I would certainly object to Mr. Diedrich testifying that the Ford Motor Company told him something. I think that's inadmissible hearsay.
Well, that's another issue.
I understand, but I would suggest, in order to expedite matters, that Mr. Diedrich make known to us who his sources were so we can cut to the quick and try and get this trial back on the road. And
I agree.
I also hope that you will make a ruling on the word match. I'm very troubled about that.
As am I. I think I've already indicated my concern with that, but it depends on what the foundation is. Maybe something miraculous has happened, but Mr. Diedrich's reputation is well known, and I don't think we're going to see anything strange. I don't think.
I should hope not.
All right.
You want me to say one thing only because
No,
we're
no,
phone call?
no. I'm not worried about that. That's a non-issue. All right, I'm going to order the prosecution to leave all of these boards here in the courtroom. We're going to recess until tomorrow morning at 9 o'clock. I'm going to direct the Sheriff's Department to allow the defendant and his counsel to remain in the courtroom with the exhibits so that they can review these matters. And we'll start tomorrow morning fresh at 9 o'clock, but we'll see where we are.
May I offer to the defense the ability to confer with Mr. Diedrich?
No, I was about to do that, too.
Okay.
I'm going to order Mr. Diedrich to remain to consult with the defense counsel and answer any questions that they have of him. All right. Would you take the exhibit down, please? Let's have the jurors, please. Mr. Fairlow, would you move the easel? All right, ladies and gentlemen, good afternoon again. My apologies to you again for the delay in getting started with the next witness's testimony. Certain things came up that I needed to discuss with the lawyers, and it's taken us obviously more time than I had anticipated. Some other things have come up that I need to deal with that I'm going to have to do out of your presence, so I thought I'd call you out, let you all go home for the day, and we'll try to start again tomorrow morning fresh at 9 o'clock. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations until the matter has been submitted to you, nor are you to allow anybody to communicate with you with regard to the case. Have a nice evening. See you tomorrow morning, 9 o'clock. All right. And I'll see counsel as soon as
we cannot instruct the witness not to prepare a report. Mr. Harmon knows that Dr. Mullis has testified in other cases, and there were never any reports prepared in those other cases as well by Dr. Mullis. But when Dr. Mullis read this paragraph, he asked me, or he was concerned that perhaps he had violated some law, and that's what Mr. Harmon was accusing him of, because he had not prepared a report in this matter. Obviously, he's not a lawyer. Obviously, discovery requested to be made to counsel, not to the witnesses themselves, just in its entirety. And I'm not even suggesting that there was any ill intent on the part of Mr. Harmon. But when you look at the record of what's happened in this case with respect to Dr. Mullis and what Mr. Harmon has said and what he did with other witnesses, in particular Dr. Reedus, all I'm asking the court to do is simply ask Mr. Harmon to stop communicating with Dr. Mullis. And if he has any requests to make, they can be made through me as counsel. And other communication will happen when and if Dr. Mullis testifies in this case. Thank you.
Mr. Harmon.
Sure. I'd like to clear up the revisionist history that Mr. Neufeld has constructed about what's happened in this case. I made a disparaging comment about Dr. Mullis, and if you revisit that, that was an inappropriate response by me to inappropriate garbage that Professor Thompson injected into this record when you interrupted him and you reprimanded him for the kinds of personal attacks that he made on me. That's the reality of what happened. So I can't.
Let's not revisit that.
Well, I'm responding to the revisitation and the reconstruction by Mr. Neufeld, and I think I have a right to do that, Your Honor, because that's not what happened. Okay. Dr. Mullis says this is harassing, and I want to read the letter. Okay. I want to read everything that I sent to him.
Well, Mr. Harmon, I do have the letter dated June 21st, 1995 before me, and I have read the letter.
Well, you know, people are going to think he's telling the truth about what he said about what's in the letter, when that's not what the letter contains. If Dr. Mullis feels harassed by a request to talk to him, the Nobel Prize winner, about stuff he's been blabbing all over the world on every tabloid that would invite him, and I think you should question Mr. Neufeld about that representation.
Well, counsel, I assume that you have videotapes of all of those interviews, and that will be ample fodder for your cross-examination. The only issue I'm concerned about is that it's clear to the court from our discussions that Dr. Mullis is an expert with substantial credentials who has been retained as an expert to consult with the defense. As such, he is somebody who is, I assume, from the representation from Mr. Neufeld, consulting with them in the preparation and presentation of whatever defense they choose to present. As such, the court's concern, obviously, as I indicated in my ruling of May 27th, is the invasion of that relationship between counsel and the expert witness, which is their work product, and it's protected by the attorney-client privilege.
That's it in a nutshell, Your Honor, and I'd be happy to address that right now.
All right, that's the issue.
That is the issue. It's the only issue. All the rest of those things are attempts to inject irrelevant material in here.
And just so the record is straight, I'll make this letter of June 21st, which includes the letter of February 2nd, which includes a transcript from another case, 2 pages of a transcript. I'll make that a court's exhibit number 1 for the purpose of this hearing, so your record is full.
Sure. I would appreciate that, Your Honor. The court mentioned your order of May 27th. I think, and I invite the court, I'm not asking you to rewrite that, Your Honor, but I'd like you to consider this point, which applies to this very situation, too. Unbeknownst to me, when I contacted Dr. Reeders, who was the subject of your court order, in fact, he was a defense expert. He was listed on the October can't recall the date, I have it here, a defense expert list. And that's a critical point. And I really invite the court to reread your order about my reprehensible conduct in light of the argument or the overwhelming authorities in this state, because that is a controlling issue. Can the prosecution contact an expert who is on the witness list, who, as Mr. Neufeld said, will testify? You've characterized him a little differently. You said he's consulting with them. Of course, he does that in leading up to it, but he will testify. That's the only reason he's on the witness list. That's to appease us that they can't sandbag us with his sudden appearance, but they can sandbag us with the content of his testimony and not provide a report. So can we contact an expert on the witness list who has publicly expressed his intent to testify in numerous media interviews? Now, I think there's a couple of subcategories to that apply to this case that help you really focus on what the issue is. Does the fact that no expert report has been filed by that person, does that somehow undermine our ability, legal ability, to interview that witness? Or put another way, if he had given us an expert report, would we be able to talk to him about the content of the expert report or the notes? We've gotten few notes from Dr. Lee. It is my position to point out the difference between Dr. Lee and Dr. Mullis and argue that there's no legal distinction, that we can contact Dr. Lee. The only reason they've given us those notes is because that's what he intends to testify about. Now, certainly, we should be able to interview him ahead of time about the content of his notes. And the fact that you have allowed them to not turn over reports by saying, well, we're not going to write them, we haven't told them not to, should that undermine our ability to interview a witness that we would be legally entitled to interview had he, in fact, written a report or had he written notes? And of course, there's no legal distinction between those two categories. So should we be able to do less by interviewing him and contacting him? Because the thing that has triggered our ability to do it is the fact that they've listed him as a witness. It's plain and simple. He will testify. We must recall that the reason behind Prop 115 under 1054A was to promote the ascertainment of truth in trials by requiring timely pretrial discovery, to say nothing about all the saving of court time about hashing these things out ahead of time. So we haven't been given anything. We're not entitled to contact those people. Well, the overwhelming authority in California clearly makes the distinction that Mr. Neufeld seems to be unaware of. And that is, and this is in both criminal cases and in civil cases, that once it is made clear that that person will testify, the work product privilege no longer applies. And the cases that stand for that proposition are, interestingly, one that the defense injected when Professor Thompson was here, County of Los Angeles versus Superior Court, 222 Calap 3rd, 647, at page 654, as well as Shadow Traffic Network versus Superior Court, 24 Calap 4th, I'm sorry, 24 Calap 4th, 699. As well as National Steel Products Company versus Superior Court, 164 Calap 3rd, 210 California Reporter. I've got a mixture of different reporters here, page 536. And a case that we cited for the proposition that they should be forced to turn over reports whether or not they exist, Woods versus Superior Court, 25 Calap 4th, 188. And those cases all stand for the proposition that once you make it clear that that witness will testify, the work product privilege no longer applies. And isn't that analogous to the situation that compels them to list a witness that they intend to call at the trial under 1054.3? The only reason Dr. Mullis is on the witness list is if they intend to call him at the trial. That's why they had to list him. Now, you have allowed them not to turn over any material that exists in any form, and I don't intend to re-argue that. We had an extensive hearing on Friday afternoon about that. Now, if they want to invoke the work product privilege, there's a simple remedy for them. Take them off the witness list. But if they take them off the witness list, they can't testify. By the court's ruling on Friday, and what they seek to do today, by overextending the ruling that you made in a different context that I sincerely ask you to reconsider now that I pointed out that Dr. Reeders was listed as of October, they have listed those people And once they are listed, we should be entitled to communicate them. If you allow them to get away with what happened on Friday, as well as impose this kind of limitation on us, your order of May 27th specifically said the harm that's involved in contacting one of these experts is the unintentional disclosure of work product privilege. And if you read those cases, that privilege does not apply because they have listed them on their witness list. So the harm that you perceived at that point, not realizing that even Dr. Reeders was on that witness list, clearly does not apply with Dr. Mullis. He's been on their witness list for quite some time, and mistakenly on my part, and I'd suggest to the court, should not apply to the order that you made on May 27th. One of the things that the court seemed to recognize that is nowhere in any of the 1054 sections, and I would hope the court doesn't intend to apply it in this context about invoking or losing the work product privilege. I think the court described some sort of fluidity exception because of the dynamics of a trial and issues evolving and some things being important and then disappearing. And that perhaps the defense could change their mind at the last minute about the nature of the testimony of any of these experts. Now, that's nowhere in any of these cases that interpret 1054, and it's certainly not in any of the ballot information about Prop 115. I would hope that you wouldn't do the same here. Because if you do, if you allow them to say, you know, he's on the witness list, he's done a lot of things for us, but until they rest, we're not really sure what he's going to testify about because we need to see the full content of their case. Well, first off, that denies us the right to a fair trial that 1054 describes. It's going to waste an awful lot of the court time when we litigate these witnesses one by one. But just imagine other subcategories of this fluidity exception. Just imagine we have the indecisive defense attorney who says, you know, I have these alternative theories, Your Honor, but I just can't decide which one to advocate until I flip a coin or I talk to my wife about it. So until that happens, I'm invoking the work product privilege because I haven't decided which areas of his testimony I intend to present. Or just imagine the alcoholic defense attorney who's in a drunken stupor all the time and because he's never sober, can't make a rational decision until he sobers up. Under this fluidity exception that seems to have been applied, I can't conceive of any reason any defense attorney would ever turn over any material under the reciprocal discovery provisions that were enacted by the voters under Prop 115. To do so under this newly recognized fluidity exception would be incompetent for any defense attorney. 1054, once again, promotes the ascertainment of truth, and it's supposed to do that in advance of the trial. That's all we want. It's the same voters who vote for all elected officials that voted overwhelmingly in support of Proposition 115. The defense has not been forced to comply with what we believe the appropriate construction of 1054.3 is, and we intend to pursue that ourselves by talking to these witnesses ahead of time. I believe that when you read the letter and the transcript of Dr. Mullis, this is his idea. This was his suggestion that he testified about in a case in November, where it would save an awful lot of time to have the scientists get together ahead of time. I cannot imagine what has happened to him since November that would cause him to change his mind. I invited him to identify the issues. I would have all the appropriate scientists there. We would sit down and discuss it so that we could focus on real issues and not the illusory issues that have been injected into this case. Furthermore, if we are denied the opportunity to have contact with those experts, which we're legally entitled to do, to seek to have that kind of a discussion with them, then we will never be able to elicit the fact that they have declined to do so, which I believe we're legally entitled to do. So with those comments, Your Honor, I'd like you to read those cases and realize the work product privilege ceased to exist the instant they submitted that witness list. The harm that you perceived concerning the contacts that I had with Dr. Reeders, which I think when you see the witness list that was in existence long before I ever contacted him, you will realize that legally we are entitled to have those contacts with them. Legally, they are entitled to refuse to talk to us, and legally we are entitled to elicit their refusal from them should they in fact testify in this case. Thank you.
I'm not going to revisit those issues because obviously Dean Ullman and dealt with those last week and they were resolved by the court. There is no legal right that gives the prosecutor the ability to send a letter to a witness basically demanding a report from him, suggesting that the failure to turn over a report may be a violation of California law, and trying to intimidate him into speaking with the prosecution. All I'm simply saying here, Your Honor, is that in light of this is not on a clean slate. I'm simply asking that since it has been communicated to me by Dr. Mullis that he regards Mr. Harmon's efforts as harassment and the efforts of the prosecution in this case as harassment, that they cease and desist from communicating with him, either by telephone or in the mail or any other means of communication. If they have something that they wish to communicate, they can do it through counsel.
All right. Thank you.
Thank you.
All right, Mr. Harmon, the prosecution is ordered to direct any communication to Dr. Mullis through defense counsel. Anything else?
Your Honor, could we consider my letter to Dr. Mullis a request for an interview?
Yes.
Thank you.
All right, we'll stand in recess. The Sheriff's Department is to make Mr. Simpson available. Mr. Diedrich is to remain. People's exhibits, photo exhibits are to remain. All right. All right, we'll be in recess. Mr. Cochran?
First of all, thank you, Your Honor, for the recess. It was necessary for us to be able to talk and discuss this matter. We certainly appreciate the court's indulgence in that regard. Your Honor, I stand before you today in a very, very serious, perhaps the most egregious, outrageous thing that's happened in this trial thus far. Excuse me one second. Yes, Your Honor. I was going to ask at the outset, this argument will be rather lengthy, and I would ask that Mr. Diedrich be excused for reasons that I think will become obvious during the course of the discussion, Your Honor.
I'm not going to excuse him at this point.
All right, well, if the court...
This is a discovery matter that has to do when things were done.
All right,
I don't think that has anything to do with his
if the
other
court
testimony.
feels at some time appropriate, then I hope the court will exercise that discretion.
All right.
The court will recall that yesterday you recessed early because of what was a serious discovery violation in which the court, in your own words, indicated that the arguments of the prosecutor were specious with regard to whether certain evidence was evidence or exhibits, and you indicated, quite frankly, they could do without that. And so after having done that in an effort to move this case along, and I think the court is aware that certainly from our standpoint we've indicated we would like to get this case to the jury as soon as possible, we made an effort, or at least started to make an effort. Your Honor made it clear to all of us that Mr. Diedrich was to remain, we would have access to look at the boards and to talk to Mr. Diedrich. The prosecutors didn't apparently understand that. You had to come back out and then ask them to leave. We were delayed by that. Finally, you asked them to leave, Sherry Lewis and Ms. Clark and the others, and they did finally leave. We then started to talk with Mr. Diedrich, Messrs. Blazer and Bailey. I had a brief encounter with him, and after a few questions from Mr. Blazer, this agent, this FBI agent, handed us a one-page report, which is supposedly a summary of what he had. He wrote this out and handed this to us. And this becomes really important because this was part of the disguise, part of the guile, if you will, of this agent in trying to throw us off. This was handed to me, actually. I then handed it to Blazer. And Blazer, however, being the lawyer that he is, continued to ask questions about reports that this man may have written and this booklet that he was carrying. I walked over at some point, and we talked about the booklet, and I then felt the need to call Your Honor out a second time, if you recall. Because there was a question, he wanted to talk with you, and I said, we don't do that in this court. You don't just talk to the judge. The judge talks to us. And I asked you to come out, and then you made an order, and as I said before, Ms. Clark concurred in that he turned that book over to us. And so now...
We summoned Ms. Clark at that point.
Yeah, we summoned Ms. Clark down, and then at some point when she sat and talked with him, Your Honor made the order, and I believe she did concur in that order at that point. The book was then...
That was to make available to you the contents of the notebook that the agent had.
That's correct.
Right.
And we've been trying to get that, and we had to have your intercession. We then got the notebook. And at that point, it became clear exactly why he'd been so reluctant to provide that notebook to us. Now, you have now been provided a copy of this 5-page, single-space report entitled The Search for the Source, Carpet Fibers Found on the Leather Glove, and the Knit Hat in the O.J. Simpson case. Now, Your Honor, yesterday you talked about sanctions and appropriate sanctions. And yesterday, my learned colleagues argued to you that preclusion of certain of the photographs was certainly appropriate, and I'll address that more as we talk about it. However, this more egregious discovery violation that's now surfaced, we think, requires even harsher sanctions. This prosecution's expert, FBI agent Diedrich, prepared a written report for this case. And this report basically summarizes his so-called rareness of the alleged beige fiber found in Bronco vehicles. And I'd like to quote from a wise judge on this very issue. Page 29, 129. Quote, if it comes to pass that there are reports or that conclusions were reached and there was a deliberate manipulation of the process and an instruction to the witness not to prepare a report to avoid discovery, then those witnesses will not testify, and that is going to be the sanction. That was an order that I made early this year. Now, Your Honor, that might sound familiar. That order, those words came from Your Honor's mouth, from Your Honor's lips, and you said it on a number of occasions.
Standing right there.
Right, and you've said it more than once. And you said it in response to Mr. Rock Harmon's ranting about our supposed experts and whether they should be entitled to reports. You made it very, very clear that preclusion was the appropriate sanction that anyone should expect. Now, the prosecutors heard that. We heard it in Sherry Lewis's latest brief She quotes your remarks also. So, Your Honor, they knew what the rules were. It became very, very clear. And for Ms. Clark to stand here yesterday and to say to you, I didn't know, it must have been in my office some other place. Ms. Clark has not had a witness for 2 months, it seems, and she's had plenty of time. This is a fine lawyer who knows what she's doing. She's running this case. She's the leader. Make no mistake, the leader on their side. She knows what's going on. They're planning. They are ending this case with this evidence. And for them to come up with this, I think you can agree with this, is absolutely outrageous and totally egregious. And so I wanted to start off with letting Your Honor hear those words, which I think are very wise words, and I think they're very appropriate. And I think they probably lead us to the solution of this problem right off. So now, in this case, not only was a report prepared by this witness, and then he attempted to avoid disclosure, Your Honor, and to conceal its existence. We learned of the report only when you interceded, and we were allowed to photocopy the entire loose-leaf binder. And what does this new discovery consist of, Your Honor? And now you've had a chance to read it, so I won't bore you in detail. But it consists of a 5-page single-spaced report, which I've given you the title of. This report contains extensive figures about numbers. And you may say, well, Mr. Cochran, you could have done this, you could have gotten this, and we're not sleeping at the switch, Your Honor. We tried. Let me direct you to the bottom of page 2 of this report. So these words, the last paragraph. On January 31st, 1995, Julia Shaw, legal representative for DuPont, advised that all production information of type 1405 fiber is proprietary. And I can tell you further, and if you want to take testimony regarding this, we have an investigator who was given disinformation by the Maslin Company. Disinformation. They didn't give us the information, even though we tried to seek it just in a general sense. The FBI could get information we couldn't. They knew they had this. And I wouldn't be surprised if Maslin didn't go along with what the FBI had already told them to do, not to give us anything. So we couldn't have gotten it. So I want to make that clear right at the outset, Your Honor. So this report goes into a number of things, total number of cars, carpets, square yardage, and that sort of thing. And in addition, Your Honor, there are 50 additional pages of supporting documents on his research into this area. We have not given you, I don't think, a copy of the entire notebook, and perhaps we should do that before you ask to rule on this matter. This includes information from many, many different sources. And just again, to briefly summarize the conversation that Diedrich had with Blazer, so you get an idea of the concealment and the guile that was involved here. Blazer first asked him where he'd obtained the information about the carpet. He mentioned Ford and Maslin. He asked him if he had any written information, and he said he did, although he did not go into detail. He asked him if we could have what he had obtained, and he said, possibly. A few minutes later, he gave us then the one-page report, which I'm going to ask to have marked as an exhibit and give you a copy of it, whatever our next exhibit is. This one-page handwritten outline providing the rough figures, etc. Blazer then asked him if this was all he had. He wouldn't answer the question directly, Your Honor. Kept saying this was the information. Blazer kept pressing him. He finally admitted there were source documents and that the one page he'd given me was not the source material. Blazer then asked him what he had. He reluctantly showed Blazer some letters that were in this binder. However, he never showed this report. He talked about it being his report or his research. Talked about starting this research last year, Your Honor, that it was completed several months ago. Clearly discoverable, Your Honor. We should have had this. And he goes on, and he did not turn this over, Your Honor, until you ordered him to do so. Preclusion, then, it seems to me, citing this learned judge, is the only reasonable remedy. Preclusion of the witness entirely, or preclusion of at least any testimony concerning commonness or rareness of the Bronco fiber. You talk about prejudice, Your Honor? Consider this. You saw the cross-examination of Bob Blazer. Thoughtful, to the point, concise. He asked questions at the end, Your Honor. The questions he asked dealt with, if you recall, the commonness or rarity of carpet fiber and whether or not police cars had been checked. If this report had been discovered, as it had been, you wouldn't have asked those kind of questions. We would have had this information. But that's the prejudice. You can't unring that bell. He asked those questions because they hid this from us. And when you talk about prejudice, you can't unring that bell if the court pleases. So we think that we've been severely prejudiced, and we meaning O.J. Simpson, who's here trying to get a fair trial, if they are then allowed to present testimony concerning this issue. We will not ask any questions on this topic during our part of the examination if and when this man testifies, if you don't preclude him totally. And we think they must also be precluded from doing the same. The elimination photographs, the elimination subject photographs, Your Honor, we're asking also they be precluded from using their exemplar hair boards and their 2 blue-black fiber boards. Prejudice, it is clear from the photos that the reference hairs of Mr. Simpson, that within their reference hairs, there's considerable variation, Your Honor, within each person. Hair comparisons are never done on the basis of photographs and never on the basis of a small portion of a single hair. Had we known that they had intended to do this, had they complied with Your Honor's rules, had they complied with the rules of the laws of the state of California, we would have handled this much differently. We would have had or made additional photographs, Your Honor, of the elimination subjects to show the great variation in hair and point out that some of the hairs of the so-called eliminated subjects, at least photographically, appear to be similar. Array the photographs of the blue-black fibers. Had we known the prosecution prepared photos, we would have compared them to the slides of the fibers to make sure that they were being presented in a way that was not misleading. Since Your Honor is aware that photographs can be manipulated, easily to make things which are dissimilar appear similar. We would have done things far, far differently at a time when they have announced to the world that they have this wonderful, compelling case, and they're about to rest. At the very end of their case, they do this, Your Honor. And so, we come back to the law, Your Honor. Ms. Clark said something very interesting, it seemed to me, in our little brief discussion of this motion. She said, well, it was just his report, as though that didn't make it discoverable. Well, let's look and see what the law says on that, Your Honor. 1054, and this Court's very aware of that, you've talked about it many, many times, deals with 1054.1, information to be disclosed by the prosecution. Let me skip down because this Court knows this by rote, I'm sure, but let me just refresh everyone's recollection. 1054.1F. Relevant written or recorded statements of witnesses or reports of the statements of witnesses whom the prosecutor intends to call at the trial, including any reports or statements of experts made in conjunction with the case, including the results of physical or mental examinations, scientific tests, experiments, or comparisons which the prosecutor intends to offer in evidence at the trial. Now, Your Honor, all we've ever asked for during the course of this trial is a level playing field. We ask they be treated just like we've been treated. And I'm sure Your Honor will do that. But in addition to that, we now have additional information that we hope to have in court today, sent from back east, where this may not have been the first time that this particular agent has done this. We expect to have information by the end of the day. There was a case in Fairfax, Virginia in 1991, where this same surprise tactic was tried by this agent and the prosecution. And certainly what the information we have is one of the reasons that the testimony was precluded was because, again, of a discovery violation and the unfair attempt to do this to the defense. Now, we hope to have that today, along with still another case in Pennsylvania we expect to have today. Now, the Court may ask, what about this whole thing with the FBI and the prosecution? Well, I need to point out to you only that Mr. Bodziak came in here and testified. An honorable witness who came in and said, I can say this and no more. He didn't become an advocate for the prosecution. He wasn't trying to hide things. In fact, in the course of the prosecution turning over all those documents, we asked the appropriate questions. That's what discovery is about. And in doing that, we were prepared to deal with that. There was no delay. They didn't hide anything back. And it pointed out, Your Honor, that Mr. Goldberg, I think, who had Mr. Bodziak, he understood what the obligation was. He works under Marcia Clark. So certainly she understood it. They complied with it with Bodziak and the FBI. Things went smoothly. There was no attempt to deceive. And we went right through it, Your Honor. So they can't come and claim they didn't understand what the deal was. But it's clear, Your Honor, that the reason we weren't given these photographs and things is because if we were given the photographs of the fibers, it would have piqued our interest. We would have asked questions about this question of the fibers and their supposed rareness or uncommonness. So this was calculated when they did this. And when the agent sat here in court yesterday and said those photographs and those boards were prepared some time ago, these reports were done in April or May, several months ago, that's no excuse for the prosecution, Your Honor. And I'm real sensitive about being the so-called head of a team where you take responsibility like a human being without gender. And so I remember in this very court a time before I was even as lead counsel, we were held responsible for something we never even knew about or ever saw. The court said we knew or should have known was the test you gave us. And that test applies not only to the defense, it applies to the prosecution. And so in this instance, we also last night had occasion, Mr. Neufeld had occasion to speak with Mr. Schulberg. Mr. Schulberg indicated that, and they went through the photographs. Of the photographs the district attorney had indicated were turned over by Mr. Dietrich to Mr. Schulberg. And by the way, they worked together. Schulberg was apparently Dietrich's boss at some point. Mr. Schulberg never turned those over to us. He thought that those photographs were for him. We never got them. But we're not complaining about that because they were apparently given him. But he now says that, and I think Neufeld will correct me if I'm wrong, there were at least 13 photographs that he has never even seen. He never got. So a further violation. Is that right? 13 that are on the boards that he never got. He never gave us any of them. But we won't complain about that. But there was a previous relation between this agent and Mr. Schulberg. And so he's prepared to so indicate that based upon the conversation last night. I've already indicated to the court that with regard to our investigation, this Maslin Corporation was not forthcoming. They did not give us information. In fact, it seems they gave us disinformation. Information that's proprietary generally, information the FBI would have that we could not get. And it's information, Your Honor, that's prejudicial to Mr. Simpson. And this is all, make no mistake about it, this is about Mr. Simpson. This is about whether Mr. Simpson can receive a fair trial. This is about a trial that started on September 26th, Your Honor, and you've gone out of your way to try to give us a fair trial. And to have this occur when we know we're coming to the end, when you have made it abundantly clear you don't want delays, that you want to move this on, when you've warned all of us there'll be preclusion if we don't comply with the laws, and we have seen the sanctimonious, pious posturing by the prosecution so many times in this case, and now we find that the most egregious violation of all, calculated, comes forward on a day when our jury is sitting back there waiting, and you told them this case is going to be over. And as the case whimpers to a conclusion, we've got to wait even now further. Because, Your Honor, we cannot just sit here and accept we haven't received certain photographs. We can't sit here and accept what's going on. This report we never got. What are we to do? We don't want to delay the proceedings. So what do you do to keep that from happening? in the spirit of what you're saying, you preclude these things. That's the only test. Even you said yesterday how tough it was as you sat there trying to think about how do I deal with this? And you oftentimes say we never make it easy on you. Well, this time it's not us, it's them have made it easy on you. And you know what, Judge? You never asked for a rose garden when you took this job. This is a tough job, and you're equal to the test, and you want to be equal in the way you've dealt with it. We felt the sting of your sanctions. We dealt with them like human beings, like we should. The prosecution has to do the same. They can't stand up here and give you a lot of meaty mouth explanations about yesterday's. Well, it's an exhibit I'm not going to use. I don't know what this is. That doesn't fly. You've got to stand up ultimately. And I call upon them now to stand up and say that they're wrong. They made a mistake. They're caught. And under what you've told us, preclusion is the only appropriate remedy. Otherwise, Your Honor, how are we going to recover? How are we going to deal with this if you don't do that? Continuance isn't going to help.
Preclusion
We don't want
is right.
continuance.
I agree.
How long will it take us to get stuff and to get up to speed on things we should have had 3 months ago? It's totally, totally unfair. And
Mr. Cochran, which of these 13 photographs were not received by the prosecutor?
I know we have a
By
one
the defense,
lawyer
excuse me.
speaking rule, but I would ask to defer. I'm not concluded. I'm not finished yet. Can Mr. Nuttall answer that?
When you're concluded, yes.
I'm not finished yet. He can use mine, Josh. They're very comfy.
And when I concluded, Your Honor, then Mr. Neufeld will stand before you and tell you that the photographs we've never seen or that Mr. Schulberg never got, and none of those reports we've seen anyway. With regard to the so-called elimination photographs, Your Honor, and just looking at those photographs, it's become clear to us. We ask Your Honor to look at one of these photographs.
I used to break dance in the 80s, Nan, in my bedroom on a piece of cardboard. I used to break dance.
With regard, as I said, the elimination photographs, I've indicated to you already that there are great variations between a single individual and a single individual's hair strand. And so we need additional time to look at that, to prepare for cross-examination. But if the court precludes that, that doesn't become a real problem for us. But further, Your Honor, and I want to show this to Your Honor, and I'll show it to counsel first, in getting copies of these photographs of alleged hair strands, this agent or someone has taken what was K, a known hair, and made it a Q. So you see Q7, which I think was O.J. Simpson, and he's made it Q8A. So that K7, I'm sorry, K7 and made it Q8A, looking at the photograph. And I'll pass this up so Your Honor can see this. And I think, Your Honor, that again, this points out the kind of things that they're seeking to do. It occurs to me that, as I said before, the prosecution understands their duty. I was reminded by one of my colleagues that when I said they made a mistake, this is more than a mistake. This was calculated.
Right,
This was
Jesse?
intentional.
Right.
This was a tactical decision to try to gain an advantage at the very end. This is because their case was going poorly. This is because they thought they were losing. They had to string or try to pull something. But it just won't work because there's something about truth, it's something about honesty that will be revealed. And that's exactly what happened in this particular case when you came out and ordered that report and allowed us to see this. So I'm going to ask you to look at those photographs. I'm going to ask you to look at the one-page report we're given, and it's just part of the deception that we were given. And finally, Your Honor, all I'm going to ask you to do, because Mr. Simpson can't address you on this issue, I'm going to ask you to do what is right and what is fair in these circumstances. We want to go ahead with this case and finish this case. This jury deserves nothing less. It's not their problem. It's the prosecution's problem when they intentionally do this, Your Honor, and they have to be held accountable. And the way you hold them accountable is to preclude this witness, or at minimum, preclude those things where they violated the discovery laws of the state of California. And there's no other remedy otherwise. Nothing else helps us, because you don't want to wait 2 or 3 months for us to get up to speed where we would have been. Do you? Would you now please hear from Mr. Neufeld, Your Honor?
Mr. Neufeld, what I'm specifically interested in which of these 13 photographs were not received.
Yes.
Beat Street.
Just
Beat
to
Street.
explain to the source of the information. I spoke to
We
Mr.
had-
Schulberg last night, and he did say that he had received some.
Huge Motley Crue banner on the wall made of cloth. And then Beat Street playing on a VHS tape. And our boombox playing Nucleus. Jam on it.
The photographs from Mr. Dietrich, and I asked him to give.
Where's Mr. Schulberg located?
He was in Virginia. He had been the head of the hair and trace unit at the Federal Bureau of Investigation up until the late 80s when he retired. And I asked him to please read off the Q's and K's on every photograph that he had. He did that. I then gave the list to Chuck Morton this morning and asked him to compare that list to all the Q's and K's on the evidence boards that have been brought into court, and to give me a list of all items that appear on the boards that weren't on the list from Myron Schulberg, and they are as follows. K53.
Which board are we talking about?
I don't have it by board. Mr. Morton simply wrote out the list of Ks and Qs. During a recess, I can actually do that, Your Honor, but I'm just going to give you the actual photograph
All right,
identifications.
K53.
K54, Q7A, Q3, Q1, Q3B, Q27, K19, Q7C, Q8B2, K18, K47, and K17. Your Honor, the only other just fact that I want to present to the court, which just for clarification, the problem with these photographs that we received last night is that because someone changed the eye description, what once was thought to be a standard hair, reference hair from Mr. Simpson, has now become allegedly the photograph of some evidence of an unknown hair in this case. We would have to go back, number one, to check whether or not on the negatives or the contact strips of these photographs to know if in fact it is a K or it is a Q. Obviously, the person who made this description on these photographs wasn't sure and changed his mind. Also, we don't know whether or not these photographs on the board have had their descriptions changed as well, or whether other photographs on the board have had their identifications changed as well because they're glued to the board. We would need to see the backs of those photographs to see on how many other occasions the prosecution did that with these photographs. And then we would have to go back and look at the negatives to see, as well as any contemporaneous notes that Mr. Diedrich made when these photographs were taken, to confirm that it is a Q as opposed to a K or K as opposed to a Q. Because, as the court can readily see, unless you have some kind of note-taking, it's easy to confuse them. There's nothing so unusual about a photograph like this that one will readily know, oh, it's a K as opposed to a Q. So these photographs simply illustrate that problem to the court.
All right, for the record, do you want to identify the markings on those photographs?
Yes, Your Honor. First is a photograph with a number on the back which says 17170 to 17179. It says on the back 408-08026. Originally it said K7. The K7 is crossed out, and written above it is Q8A. The second photograph, the numbering is 17, and there's a cross out on the number, Your Honor, but it looks like 17240 to 17249, but those numbers themselves have been crossed out and written over. And it then says 408-08026. Once again, there was a K7 which has been crossed out, and written over the K7 is Q8A, as in Albert.
Thank you.
Thank you.
Ms. Clark. I'm concerned about two things. The rareness report, and I'm concerned about the 13 photographs.
I only counted 11, Your Honor, but
I counted
be that
13.
with respect to, let me first start out with the report then. First of all, you know, Mr. Cochran has argued to this court in bad faith. He's very well aware of the fact that the prosecution did not know about this report until it came to the attention at the same time that it did for the defense, at which point I readily agreed it should be turned over. I had never seen it. I did not direct that it be prepared. I did not know the research was going on. I found out about the report last night and immediately turned it over. That's a far cry from the egregious and willful violations perpetrated on us by the defense throughout this case. Hiding witnesses, hiding reports. And what's very important to point out, Mr. Cochran read your words, but he obviously did not understand them. The words that he read stated that conclusions that are reached by expert witnesses must be turned over. Conclusions of this witness were indeed turned over. And this court also stated that if instructions were given not to prepare reports, preclusion would be the remedy. At no time has anyone on my team ever instructed a witness not to prepare a report, ever. Quite the contrary. Every witness, if we knew about anything ongoing, was instructed to prepare a report for immediate production. This research that was conducted by Agent Diedrich was done for his own purposes. Yes, tangentially, yes, this case triggered that. But this is something that is ongoing by all of the agents at the FBI. They don't just sit behind a microscope. When they see a fiber, they investigate the background. Now, what is important here is that obviously the reports turned over to counsel indicated very clearly what his conclusions were, that he identified the Bronco carpet fibers as being the source of the fibers found on the Rockingham glove and on the knit cap, and he gave enough information for them to go forward and contact Maslin. Obviously, then, the conclusions and opinions of the witness were turned over in an adequate form to allow the defense to do further inquiry. That is the point of discovery, so that they are informed, so that they can do their own investigation. Now, Mr. Cochran complained only today of the fact that months ago, his research went nowhere, that Maslin was stonewalling, that they weren't being helpful. On previous occasions, when they have had trouble with a witness or with some agency getting information from them, they have not been shy about asking for our assistance, for the court's assistance. And where is the subpoena that they could have issued on Maslin for this information? Where's the request to the court for assistance to gain some help in getting the information from Maslin? They obviously knew where to go to get it. They obviously made these phone calls. They got some information from them. Why was no one told that they were having difficulty? They could have even done it ex parte with the court and never chose to do so. And now they're complaining that their own failure has caught them off guard. They had the information to go forward and do the research. They did a limited amount, stopped, and decided it wasn't worth it and it wasn't important to them. Agent Diedrich did. He made the phone calls. Now, the problem with their position is that it's specious. They have the conclusions, they have his opinions. That's what the court properly indicated we had to turn over. Now, the cases that counsel is relying on indicate that we are required to turn over the reports of witnesses, their opinions, and their conclusions. And that is what we did. And that's what Agent Diedrich included in his reports. The report that is in front of this court now indicates only the information obtained from Maslin, pursuant to routine telephone inquiry that is conducted by the FBI whenever they find question fibers of an unknown source. And that's what he did. So what that is inquiry that supported the ultimate conclusion and opinion that the defense has had for months. We didn't delay in turning over Agent Diedrich's reports and notes, all of them. They've had them. Moreover, the complaint and the hue and cry over these photographs is ludicrous. They've had this evidence not once, not twice, but 3, and I think possibly 4 times in their custody, with multiple experts examining all of the evidence. Could they have taken photographs? Absolutely. On any of those occasions they could have. And what precludes them from doing so now? Nothing. Nothing. They're saying that they're very concerned about the photographs being representative. Fine. You know, you've taken the evidence 4 other times. You know, they didn't know what to do with it then. They didn't know how to take photographs. Now that they have an idea of how to do it from Agent Diedrich, maybe they can tell their experts to do it. Certainly the court will not hesitate to let them have the evidence again. But it's not a question of them not knowing what is here, not knowing what the conclusions were, not having an opportunity to have every expert they can get their hands on examine this stuff and come to his own conclusion. They've been denied nothing. There has never been a defendant in the history of this state, I warrant, that has had everybody bend over backwards for him the way this one has. We have shut down laboratories. We have sent evidence all over the country multiple times. We have allowed defense experts into our laboratories multiple times. We have dug up records going back God knows how long from other cases for this defendant on multiple occasions, reams and reams and reams of discovery. And they don't get some photographs of evidence that they've had in their control and possession on 4 separate occasions, and they're complaining. Go take photographs. Fine. This is nothing but a graphic depiction of what was seen under the microscope by our expert and by their multiple experts. They want to take pictures of their own. They are entitled to do so. Do I regret that the photographs they complain of were not turned over? Yes. We have nothing to hide. There is no reason for them not to have seen them, other than that it was an oversight. And although Mr. Cochran waxes eloquent about how I should be taking responsibility for the failure to turn these over, and I do, I've never heard Mr. Cochran do so for the defense. Never, not once. It's everybody else's fault, and we didn't know, and all that. I'm telling the court I take responsibility. I do. I do. I wish it had been turned over. Is it all this egregious? No, it's not. No, it's not. They have had the conclusions, they've had the opinions, they've had all the reports that are pertinent, that are discoverable under the statute. They wanted the underlying research done by Mr. Diedrich. Fine, now they have it. Had I known of it earlier, they would have had it earlier. They got it as soon as I knew about it. And the court knows that's what happened. The court was here yesterday when I was called down and shown for the first time the book prepared by Agent Diedrich that contains that report. I read the report myself last night for the first time. What the defense thinks they're going to do with the fact that an inquiry by telephone gave certain dye information, formulations, and calculations, I have no idea. But they're entitled to do it.
Doesn't this report really speak to the rareness, the relative rareness of this particular fiber? And doesn't it eliminate, say for example, one of the things that piqued my interest yesterday, and I asked Mrs. Robertson to pull up the crime scene photos to see how many Ford automobiles were driven by the police officers to the crime scene. And I was sitting here looking to see how many Ford Tauruses there were at the crime scene. But now I know that Ford Taurus automobiles are eliminated from this as a source of carpet,
Right.
which I found interesting.
Right. Right.
But the thing is, this report tells me how relatively few Ford Bronco automobiles there could possibly be that would, registered in the county of Los Angeles, that would have this carpet fiber, this particular formula in this particular color. And that's very compelling circumstantial evidence. I mean, it really narrows it down to where this carpet fiber came from, don't you think?
And I agree with you, Your Honor, but this is not, the problem I have with this is that this is information that is reposed in a third party. This is not information that is retained by the FBI.
Let me ask you one other question. When was this report completed by Mr. Diedrich?
I have no idea.
I don't consider it a report. I just consider it a narration of my investigation.
When was it completed?
I'm sorry?
When was it completed?
Sometime this year, I don't recall.
A month ago? 2 months ago?
A couple months ago, probably.
Okay. All right, Ms. Clark, any other comment?
Yes, Your Honor. The problem that I have with the defense argument is that obviously, they're arguing out of both sides of their mouth. They say, we don't have enough information, it wasn't fair that we didn't get this. Obviously, they did get enough information. They went to the source. They asked the questions. Their failure to follow up on the refusal of the company by requesting the assistance of the court or the prosecution is up to them. They chose to drop the ball at that point. That's their choice. But to now turn to us and say, it's our fault that they didn't follow up on that line of inquiry, we are required to give them the information necessary to challenge the evidence, and we did. And they began to do so, and then dropped the ball. Now, had they gone to the court, requested assistance, and then not been able to get the information, I can understand that. But they dropped it. They went to Maslin, they didn't get the answer, or they did get an answer. I don't know what exactly occurred, but obviously they had enough information to follow through, and that's really the bottom line. That's what discovery is about. Now, I'm not saying I don't wish that we had turned this report over earlier. I do, because we don't need to be having all these delays right now. Is it compelling in the sense that this is an egregious violation? Again, I can only tell the court the defense was given information that they could have gone and followed through on. They did begin to, so obviously they had enough. And now that they do know, they can give it to their experts, and they can have their experts examine the reports, examine the underlying information, talk to anyone from Maslin that might help them, speak for their agent Diedrich if that will help them. They're not precluded. They have a defense case to put on. But to preclude the people from putting on important evidence like this, in light of the fact that they have the report that contains the opinion and the conclusion of the expert with sufficient information furnished to the defense to follow up on that and see what they could find out. I mean, they have everything that they are entitled to under the law. What they're complaining is that something else was prepared that they did not see that simply documents Mr. Diedrich's further investigation through phone calls to Maslin. This is a third party.
Does the report turned over by Mr. Diedrich previously contain this information?
The report turned over to the defense?
Yes.
You mean the one yesterday or earlier?
No, previously. His previous
No, it doesn't
reports.
contain the detailed information. It says it contains the opinion and conclusions about the match and about what fibers matched. It also contained information, I think, about the type of carpet fiber that it was, manufactured by Maslin.
Any indicia of its rarity? Number of vehicles produced that have this carpet?
I
this
don't
particular
believe so.
color?
I don't believe so because I didn't know that till last night. So if I didn't know, let me indicate what the photographs are that the defense is.
I was just about to ask that.
I thought so. Okay. The K53 and K54 are the exemplars of Kato and Chachi, the dogs. K47 is exemplar from Colin Yamauchi.
K7A, I'm excuse me, Q7A,
No, I'm sorry, that's K47.
K47.
Now that's pretty interesting. If those are the photographs that the defense claims that they don't have, then they must have photographs of the other police officer exemplars that we took and lab personnel. If that's the only one. Because that's one of that series of the police officer and lab personnel elimination standards, Your Honor, that we have on the board. K47 is one of those.
All right. Go ahead.
So K17 is the exemplar from Nicole's dress. K18 is the exemplar from Ron Goldman's shirt.
K18.
18, yes. K19 is the exemplar from Ron Goldman's jeans. Q27 is fibers from the defendant's socks. Q8B2, fibers from the blue knit cap. Q7A, fibers from hair and fiber. I'm not sure if these are hair or fiber, Your Honor. Q7A from the Bundy glove. Q7C from the Bundy glove. And then Q1, Q3, and Q3B are from the Rockingham glove. I should indicate also that Tony Longhetti took 65 photographs to Mr. Schulberg along with the evidence. There were 30 additional photographs that were left with him because they were extras. And Mr. Neufeld asked him to give the photographs to him. He said he would. However, he's since checked the evidence log and seen that Tony Longhetti took all the evidence photographs back, and he therefore is probably not going to return the photographs to Mr. Neufeld. And Mr. Schulberg should talk to Mr. Neufeld about this. In any case, 65 photographs were given to Mr. Schulberg back in September of '94.
But did they include these?
Well, I'm taking Mr. Neufeld's word for it that they didn't. That's what he says. I don't know.
All right, the Cato and Chachi exemplars I'm not particularly excited about. I don't think either side really cares about the dog fibers. But the Bundy glove, Ronald Goldman, I mean, these are critical fibers.
These are just photographs, Your Honor. I know the court, I'm not going to say it again. I just think that we probably see the issue differently, but the defense has now had all of yesterday, last night, and this morning to look at all of these photographs. They've taken photographs of the boards themselves. How much more would they have done had they had these photographs earlier? If the defense is complaining that they want the opportunity to take photographs too, nothing prevents them from doing that. The evidence is readily available. It hasn't gone anywhere. It's in the same condition it always was. Nothing has been denied them. They are not precluded from it. And now they have examined all of the evidence. You know, by way of example, counsel points out that Bob Blazier asked a series of questions that would not have been asked. Well, certainly they would have. They were pointing out the fact that LAPD didn't do the research when they know that the FBI did. So, you know. So I don't think that it would have changed that cross-examination any. But the defense has now seen all of the photographs they're telling the court now that they did not have. They have seen. They have taken pictures of. How long do they need to look at a photograph to be ready for cross-examination? I mean, isn't that the bottom line here, Your Honor? We have an exhibit they saw the day before. We intend to introduce it. They've had now additional time to examine it. And how much more would they have done if they'd had the photograph a month ago?
All right, any other comment, Ms. Clark? Certainly. No, she's entitled to hear what it is you're saying.
Cite to the court a couple of cases on the discovery issue. Hines versus Superior Court, 20 Cal at 4th, 1818. Page 1822 and 1823. And Sandifer, Wood versus Superior Court, 25 Cal at 4th, 178, at page 182. Both of which stand for the proposition that the underlying data on which an expert relies is not the subject of a discovery statute that is compelled to be turned over. We did not intend to offer the information given to Mr. Diedrich from Maslin Industries, simply that it was his opinion that the fibers matched, and show the fact that Bronco fibers did change over the years through the photographs, which pins it down to a 94 Bronco or late 93, I think we said. And that's it. We were not going to offer the information that Mr. Diedrich obtained from Maslin Industries, although there would arguably be some basis to do so because an expert can testify to some of the hearsay he relies on. That was never the intent. It wasn't the intent because I didn't know about it, but I could certainly understand the court precluding him from referring to that at all in light of the discovery issue. But at least according to the case law, the kind of information we're talking about with respect to the research done with Maslin is not discoverable in any event. His conclusion is, and it was turned over. With respect to the rarity,
was the fact that it's consistent with the carpet in a late 93, early 94 Bronco,
We
was
got
that in Mr. Diedrich's original
15
report?
minutes to get sanctions in here, guys.
No.
Fingers crossed.
no, it was not. I can only come back to the fact that this was information that was readily discoverable by the defense as well, though. You know, it's not as though this was something that was reposed in the FBI. This is a third party that the defense had access to, gained access to, and could have sought further assistance from the court to gain further access to. I don't understand why subpoenas weren't issued for it, but they didn't.
All right, Ms. Clark? Anything else?
No, that's it, Your Honor. I just, they've seen all the photographs now. They've had overnight to look at them. They've had all day to look at them
Sit down.
yesterday as well.
Sit down.
If they
You're
want
done.
more time to look at them, I don't see what, the problem is this, Your Honor. Defense complains that they need 2 to 3 months to prepare for this, which is ridiculous. They've had 6 months. This case has been, they've had the reports concerning Mr. Diedrich's conclusion about the fact that the Bronco carpet fiber from O.J. Simpson's car matches those fibers on the Rockingham glove and the knit cap for at least 6 months, if not more. They've known where to find the information concerning the production of that carpet type for at least 6 months, if not more, by their own admission. And now they're complaining that they didn't do further or better research, and that's not our fault, and it's not our obligation. And if they're having trouble getting that information, it's up to them to let us know. We can't go knocking on their door and say, excuse me, have you had any trouble getting information lately? That's something that they have to tell us. And with respect to the photographs, what benefit would they have had to see the photographs even if they existed 6 months ago? They look at the photographs. They want to take their own. They can take their own. They can still do that. And that's the bottom line, is there is no prejudice and there is no harm other than their own failure to follow up on their own lead.
All right. Counsel, let me just make a comment. I don't find the Hines case to be appropriately cited in this situation. The Hines case at 1823 states as follows: the report of a non-testifying expert, which is in some way utilized by a testifying expert, is not a document, at least in ordinary circumstances, which the defendant will intend to offer in evidence. It is not, therefore, literally embraced within the description of the statute. That such subsidiary report may be discoverable as an aspect of cross-examination of a testifying expert does not undermine this conclusion. This is a report by a testifying expert, not a non-testifying expert. So the Hines case has no application whatsoever to this situation.
Well, we're talking about the information obtained from a non-testifying party, which is Maslin.
I don't care what you call this. This is a report.
Thank you, Your Honor. I'm not going to stand here very long, Your Honor, because you've heard all this and the issues are clear. Certain things I just feel compelled to say, and then I'll sit down. Mr. Neufeld wants to make a clarification regarding the photographic exhibits, and I'll ask you to hear that also. Just briefly, Your Honor, we've heard a lot of legal mumbo-jumbo with regard to, well, this is a report, and you just said it best. This report, Your Honor, is entitled The Search for the Source, Carpet Fibers, etc., the O.J. Simpson case. And if you look at this report, Your Honor, on every page, they're talking about O.J. Simpson. Throughout this report, that's folly for her to stand and say that. You saw the report, the booklet this FBI agent had O.J. Simpson on the outside. And so when she talks about Mr. Simpson getting special favors, never before has there been a defendant who's been subjected to every law enforcement helping in the case ever in the history of the state. We have to ask for things because we're fighting the power of the government and a man who's innocent. And that's what we're trying to do here. So let's make that clear. But I'm not, you've heard all that. And they can cite you cases as they oftentimes do that are never on point. But I'm going to cite you Ito on the law. Ito on the law in this case. And it says, if it comes to pass that their reports are conclusions which were reached and there was a deliberate manipulation of the process, there'll be preclusion. You said that. That's the relevant law in this courtroom. We all abide by that. We've lived with that, and we do accept responsibility, contrary to what she said. She tried to accept it, then she tried to weasel out of it. And you have to accept it or not accept it. And there, it's very hard for Ms. Clark to say that she was wrong or this was intentional. And then she says, well, they saw the photographs overnight. Your Honor, I remember one time there was a situation where you gave them, like, as long as they wanted. They asked one time for a month over some little tiny thing that they wanted. And we were aghast. They wanted a month. And it was early on in the trial. I don't think it ended up being a month. But now she says to us, we saw the photographs overnight. When we finished seeing those photographs last night, Your Honor, everything back east was already closed. And the last thing I wanted to bring to your attention is this whole thing about Maslin. And it was very interesting for the prosecution to make these kind of thoughts, these largesse thoughts. I used to be a prosecutor, so I can understand it. When the FBI calls Maslin, it's far different than a defense investigator calling Maslin. And Maslin gave us disinformation, saying this carpet was common, is what happened. Was common, not rare. And that's the whole thing. Every time you ask a question about that report we were given, which throws us off, they have to then come back and say, well, this rareness and commonness thing, well, that's something I wasn't going to use. Well, as to whether or not Ms. Clark knew about this or not, she should have known. And that's the test you applied to us, Your Honor. She should have known. She's the leader of that team, and she's a very thorough lawyer who hasn't had a witness in a long time, was building to this point. So it seems to me, if Mr. Diedrich kept this from her, then she should take it up with him. But I would suggest that he knew it was there, and even now, Your Honor, he sits over there trying to tell you this isn't a report. This is not a report. I don't know what you'd call it. And I think that's the essence of it. So you've listened to us. Now it's time for action. You've heard us. It's up to you. We just want a level playing field. We want fairness here. And fairness, Your Honor, is preclusion. We don't want a continuance. We want to hold them to the same standard everybody else. And then all I have to do is cite Ito on law. I don't have to miscite any cases. I can cite, Your Honor. That's all I have to do. Would you listen to Mr. Neufeld now, briefly?
Just to clarify which photographs we're talking about.
Your Honor, there was a mention by Prosecutor Clark about K47. Mr. Morton says that that's actually it's a standard reference fiber from Q47, which is the knit hat. Apparently we can check it out. I mean, it's not a big deal. There may be just a misunderstanding here. That may be one of the standard blue-black fibers from the knit cap. So that's why it was a Q, it's not a K. We didn't include in this list any of the photographs from the elimination board. We never received any of them, period. So that's not on this list. None of those photographs were ever turned over.
All right, let me see K53 and K54. Mr. Escobar. All right, thank you. All right, may I see? I want you to just put the next board up, Mr. Escobar, and let's see what's there. All right, this is the known head hairs from Nicole Brown Simpson compared with some of the Q series. All right, on this particular board, Mr. Neufeld, are any of these photographs, any of those that were not turned over to Mr. Schulberg? Sure. Sure.
May you go to the well, Your Honor?
Yes, you may. Any of these on my list?
Q1 is on your list, Your Honor. We didn't get Q1.
They had Q7B and Q23.
We got Q7B, and we did get Q23. We did not get the Q1.
No, I just found it. All right, thank you, Mr. Escobar. All right, this is known head hairs from Ronald Goldman, head hair from Ronald Goldman's shirt, compared with Q3C and Q3C. And Q23. I think you have all of those.
No, they had all.
Yes.
All right. All right, the elimination board. All right, thank you.
Yes. They had all these.
Q8C. It wasn't on your list, but he definitely says Mr. Morton looked at it very quickly this morning. But it's not on Mr. Schulberg's list. So I have Mr. Schulberg's list here also.
Well, I have 13 photographs here listed that you gave me, and Q8C is not one of them.
No, what I'm saying is, the number 13, even Chuck Morton's very quick review this morning of the boards, comparing them to a list that I received last night from Aaron Schulberg. What I'm saying is that this is one that Mr. Morton apparently missed in his very quick review this morning, but it's not on Myron Schulberg's list. The additional problem, Your Honor, with this exhibit, which I'm going to ask the court to consider, is the problem where we have photographs which were originally K7s, which are now called Qs. And
So you don't have Q8C, is that the one?
That's correct, Your Honor. But then we have the
How are
additional.
you determining what we do or don't have?
This is hearsay from Mr. Schulberg.
What?
This is hearsay from Mr. Schulberg,
And how do you know that what Mr. Schulberg's referring to is what you think it is?
which is why I asked where Mr. Schulberg
You
was, but
probably
we'll
could,
determine that when
John.
I want to know which are the contested photographs before we go any further. All right, let's see the next board.
Just the other problem again is these two photographs, Your Honor, on that one, that's all.
Not interested in that issue right now.
Okay.
Yeah, every time the court reporter went over there with them. Yes, without the jury present. Yeah, all the motion hearings are in there. Sanctions in there.
This was the board that Mr. Morgan didn't actually see this morning because it was being photographed. So there were 4 additional items that do not, are not on Myron Schulberg's list that he gave me last night. They would be Q10, Q13,
I bet there's some law classes that law students attend
Q18,
where the professors make them go through
Q10,
this case.
Q13.
yeah, and Q18.
We're doing
Then there's this
law
which is
school work
Q47 here
for
is a-
fun.
is a cat. The Q47 that Mr. Schulberg gave me, he said was a fiber, not a hair. I'll just have to get clarification on them. That's all I know.
All right, let's see the next board.
I mean, that's one of the problems with.
Next.
Good question. Maybe back then steno machines were made of better stuff and it made it through the whole case.
Here's another Q47.
I should have pulled it out when Johnny Cochran came up.
That
Pulled
makes
out my
sense. That's
popcorn.
the fiber that Mr. Schulberg was talking about.
We have the second Q47.
We do not have K18. Never got K18. We do not have Q3B. We do not have Q1. We do not have Q8B2. And we do not have Q7C. But we do have Q47 fiber.
And the Q47 on the known head hair from the defendant
We do not have.
was in fact a hair.
Yes.
So you have 240 Q47s. All right, next one, Mr. Escobar.
I got good news and I got bad news from what I just saw. Let me see if I can show the whole class.
All right, this is known fibers from niche.
Shut up, Ito. Just shut up. I've had enough of you for one freaking day. Please just shut up, Judge Ito. Okay. Oops. Darn it, I don't want to change this, but here I go changing it. Okay. Here's what I just saw, guys. If you fast forward in the video, we are halfway through this video. And if you go a little bit further, boom. We get a new witness on the stand. I know his name starts with a D. That's all I remember. Alright, now that's the good news. We get a new witness tomorrow. Now the bad news. He's here. He's here. So he's on for at least, yikes many more. Another week. We get him for a week. Week. They're road apples. It's not horse poop. Oh man, shoe fly. Guys, if you have not ever eaten shoe fly pie, it is sweet and delicious. Sweet and delicious. I like flying. I like flying a lot. I like flying, but I hate flying. Oh my god. If there were just 0 people involved. If I could fly with no people, Is he an FBI agent? Is that who he is? Let's go. Okay. Okay, that should be interesting. Exactly, Zach. That's exactly right. If I could just fly without all of the BS that goes along with flying, I would fly all the time. I would go visit CJ. I would go visit everybody on the list. Boop, 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 boop. I'm going to go fly. I mean, Josh just flew. But you know how he is when he gets in a plane. He talks to everybody. He was talking to the people 3 rows up and 2 seats over. Having a whole conversation on that plane. I know it. Hey, where you going? Everybody around heard his conversation. And then what he did to that bathroom. Anyway, Josh, I'm glad you're home. That would be cool. I don't know how many more witnesses the prosecution has, guys, but it is not a lot. It's just not. We are almost done. I'm not going to say it again. You all know what I wish they would have said. They didn't. Okay, Jesse, that sounds like a plan. Do you have a bar? How far away is the nearest bar? I know you made friends in the plane. I know you did. Because I have you under surveillance. But also because it's you. It's you. You were telling everybody on that plane you better make spare keys. Alright, I gotta get to work. I wonder if I can call in sick today because I'm very, very sick. I can't come to work today. I died. I'm sorry. Be there tomorrow. Lancaster, you're flying into the little Lancaster one? Pick up a cake, T. 9-minute walk. Not walking home, it won't be. Walking home, that 9 will be a different number, guaranteed. Alright, guys. Behave, be good, be nice to everybody today. And I will talk to you again very, very soon again. Bye, guys. Thank you.